has done their own variation version of it. And so there's a lot of levers and nuance, again, and complexity to making sure that these are done correctly.
Why do we have guns? Why do we have the Second Amendment? Is it to hunt? Sure.
And you should have a right to bear arms in this amazing country that we all live in. But you should be responsible in bearing those arms.
Simply because the senior citizens and law-abiding citizens like myself is being victimized.
And ever since then, the court has declined to answer the question, well, what about the part of the Second Amendment that says keep and bear arms?
Supreme Court and Second Amendment. Over the years, the United States highest court has consistently affirmed that the Second Amendment is not an absolute right and is compatible with reasonable arm regulations. Despite this, the persistent efforts of the arm lobby to challenge and undermine essential arms safety laws have continued to shape the legal landscape. Two landmark Supreme Court rulings, District of Columbia v. Heller and McDonald v. City of Chicago, have played pivotal roles in defining the contours of the Second Amendment. In 2008, the Supreme Court broke a nearly 7-decade silence on the Second Amendment with its decision in District of Columbia v. Heller. The case revolved around Dick Heller's challenge to the District of Columbia's ban on handguns in the home. The court, in a majority opinion authored by Justice Antonin Scalia, ruled in favor of Heller, affirming an individual's right to keep handguns in the home for self-defense. Crucially, Justice Scalia emphasized the limited nature of the ruling, dispelling any notion of an unrestricted right. The court explicitly stated that the Second Amendment does not grant individuals the right to keep and carry any weapon for any purpose. Scalia's opinion acknowledged the need for reasonable regulations, stating, like most rights, the right secured by the Second Amendment is not unlimited. The Heller decision outlined examples of presumptively lawful regulations, providing a framework of arm control measures. These included laws that prohibit arm possession by individuals deemed dangerous, forbid arm possession in sensitive places, such as schools and government buildings, impose conditions on the commercial sale of arms. Contrary to the hopes of the arm lobby, the Heller decision did not grant a blanket endorsement of unlimited arm rights. Instead, the subsequent decade of post-Heller litigation demonstrated that the ruling was compatible with various life-saving arm laws in place today. Courts have consistently upheld regulations aimed at protecting public safety while respecting the core principles established in Heller. McDonald versus City of Chicago. In 2010, the Supreme Court heard a case challenging Chicago's handgun ban, one similar to DC's recently overturned ban. Otis McDonald and 3 other Chicago residents sued the city over the ban, and because the Heller decision only applied federally, the Supreme Court agreed to hear the case. In McDonald v. City of Chicago, the Supreme Court held in a 5-4 ruling that the Second Amendment applies to state and local governments in addition to the federal government. While Chicago's complete handgun ban was overturned, the court reiterated in McDonald that a wide variety of state and local arm laws are constitutionally permissible. The McDonald court stated that it is important to keep in mind that Heller, while striking down a law that prohibited the possession of handguns in the home, recognized that the right to keep and bear arms is not a right to keep and carry any weapon whatsoever in any manner whatsoever, and for whatever purpose.
Donald says he wants the right to protect himself from gang members who threaten the Morgan Park neighborhood where he lives.
And ever since then, the court has declined to answer the question, well, what about the part of the Second Amendment that says keep and bear arms?
McDonald's case will be argued before the nation's high court next week
for bucking the nation's highest court on Second Amendment interpretation.
Simply because the senior citizens and law-abiding citizens like myself is being victimized.
Post-Heller litigation. In the aftermath of the landmark Supreme Court decision in District of Columbia v. Heller, the arm lobby has persistently sought to expand the interpretation of the Second Amendment, aiming to invalidate a myriad of existing arm laws. Despite their claims, the courts have consistently refuted these attempts, reaffirming the constitutionality of crucial arms safety regulations. This post-Heller litigation landscape serves as a testament to the judiciary commitment to balancing individual rights with the imperative of public safety. The arm lobby, in its pursuit of a broader interpretation of the Second Amendment, misrepresents Heller, falsely asserting Supreme Court support for their cause. However, the explosion of litigation following Heller has demonstrated that the decision was not a carte blanche for dismantling arms safety laws. Rather, it provided a nuanced framework, acknowledging the necessity of reasonable regulations to ensure public welfare. Across the country, courts have consistently turned to Justice Scalia's words in Heller to uphold the constitutionality of essential arms safety laws by aligning with the sentiments of the majority of Americans who advocate for sensible arm regulations. These courts underscore the critical role of such laws in maintaining community safety and safeguarding constitutional rights, such as the freedom to assemble without fear of armed crime. Post-Heller litigation has seen a diverse array of arms safety laws being upheld as constitutional by lower courts. These include laws restricting the concealed and open carry of loaded arms in public, bans on assault weapon, large-capacity magazines and silencers, while Second Amendment Court Watch provides an up-to-date overview of current Second Amendment challenges. Next step. For more than 25 years, the Giffords Law Center has been fighting for the validity of arm control laws. It has filed more than 125 amicus briefs in significant court cases and consistently helped prove that arm control policies are completely consistent with the Second Amendment. The arm lobby, meanwhile, has spent millions to appoint justices who oppose arms safety regulations to federal courts, including the Supreme Court. The arms safety regulations that we know save lives are still being fought for by our legal specialists.
The right of the citizens to keep and bear arms has justly been considered as the palladium of the liberties of a republic.
Has done their own variation version of it. And so there's a lot of levers and nuance, again, and complexity to making sure that these are done correctly.
Since it offers a strong moral check against the usurpation and arbitrary power of rulers.
Saying that the Second Amendment does provide a right to have a gun outside the home.
And you should have a right to bear arms in this amazing country that we all live in. But you should be responsible in bearing those arms.
We provide pro bono legal assistance to communities and, upon request, model laws. In crucial Second Amendment cases, we oppose the arm lobby, pursue affirmative action to demand important arms safety legislation, and oppose careless legislation that endangers Americans and the public. They collaborate with attorneys from the top legal firms in the country through the Arms Accountability Council Task Force. Fact: to lower armed crime and safeguard Americans' right to live free from armed crime. Hawaii Top Court. The U.S. Supreme Court, which has a conservative majority and has sustained decisions that have increased arm rights, was attacked by the Hawaii Supreme Court for upholding the state's regulations, which usually forbid carrying an arm in public without a license. In a unanimous 5-0 ruling that opened a new tab on Wednesday, Justice Todd Edens stated that states retain the authority to require individuals have a license before carrying arms in public, in reference to the Second Amendment of the United States Constitution. The court, which consists of 2 judges nominated by Republicans and 3 appointees of Democratic governors, declared that it approved of recent decisions made by the U.S. Supreme Court regarding the Second Amendment's guarantee of the right to keep and bear arms. The state's constitution states, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed."
A Hawaii Supreme Court decision about gun rights is making waves in Hawaii and beyond.
Why do we have guns? Why do we have the Second Amendment? Is it to hunt, Sure.
The Hawaii Supreme Court says there is no state constitutional right to carry a firearm in public.
Court said that the Second Amendment does provide an individual right to have a gun, but they said it was at home for self-defense.
A move that some say upholds local gun control, but others argue does nothing.
After arresting Christopher Wilson for trespassing on someone's property while carrying an unregistered arm, the court overruled the lower court judge's decision to dismiss 2 charges against Wilson. The verdict was praised by Democratic Attorney General of Hawaii Ann Lopez as a landmark decision that affirms the constitutionality of crucial arms safety legislation. Benjamin Lowenthal, a Wilson attorney, said he and his associates were analyzing the decision and taking stock of our options. A trial court judge determined that, in view of the U.S. Supreme Court's historic 2022 decision in New York State Rifle and Pistol Association v. Bruin, Wilson's Second Amendment right to keep and bear arms had been violated by the accusations against him. The court's conservative 6-3 majority in that case acknowledged for the first time that a person's right to carry a weapon in public for self-defense is protected by the Second Amendment. A new standard for evaluating arm regulations was also established, stating that limitations have to be consistent with this nation's historical tradition of arm regulation. Although the test has resulted in other verdicts invalidating federal arm laws, Eden stated in the decision on Wednesday that Bruin did not prevent states from enforcing license requirements for arms. Additionally, he took issue with Bruin's interpretation of the state constitution, argued that it differed from the federal one as upheld by the U.S. Supreme Court, time traveling to 1791 or 1868 to see how a state regulates lethal weapons. Per the Constitution's democratic design, is a dangerous way to look at the federal Constitution. He stated, "The Constitution is not a slaying pact." That's all for this video, folks. See you next time.